Case 1. Marty Heimabaugh. A licensed practical nurse was overheard telling colleagues she would make sure a patient would not make it through the day. That statement, documented in a state investigatory report and repeated under oath, became one of the central pieces of testimony in what investigators would spend 15 months piecing together inside a 115-bed nursing home in Woodstock, Illinois. 6 patients, 6 deaths, a period of less than 6 months, and a pattern that coworkers noticed long before investigators arrived. This is Case 1. The facility was Woodstock Residence Nursing Center, located at 309 McHenry Avenue in Woodstock, McHenry County, Illinois. It was a licensed long-term care facility operating under state oversight, the kind of place families trusted with their most vulnerable relatives: elderly patients, hospice patients, individuals with chronic conditions who required around-the-clock professional nursing attention. Marty Heimabaugh was a licensed practical nurse employed at that facility. She was 57 years of age at the time of her arrest in 2008. She had worked in long-term care nursing, and her colleagues knew her, worked alongside her, and, according to the testimony that would later emerge in court, witnessed conduct that alarmed them. The deaths that formed the basis of the criminal investigation occurred between the 2nd of April and the 18th of September 2006. Over that 5.5-month period, 6 patients at Woodstock Residence died under circumstances that some nursing staff found difficult to explain by natural causes alone. The patients involved were primarily hospice-designated or terminally ill individuals, men and women who were receiving end-of-life care and who were considered fragile. Among the publicly named victims were Tony Hodges, a hospice patient being treated for liver cancer; Virginia Cole, who died on the 10th of September 2006; John Sherman, age 52, also a hospice patient with liver cancer; and Jean Hanna, who died on the 8th of April 2006. The question that investigators would spend more than a year trying to answer was straightforward but deeply consequential. Were these patients dying because their conditions had progressed to the natural end of life, or were they dying because of something being done to them? The investigation did not begin with a phone call to police. It began with nurses talking to one another. Fellow nursing staff at Woodstock Residence grew alarmed at the pattern they were observing among the hospice and terminally ill patients assigned to Heimabaugh's care. The deaths were not random. They appeared concentrated. They appeared connected to specific shifts and a specific nurse. At some point in 2006, concerns were formally elevated. The Illinois State Police opened an investigation that would run for 15 months, a slow, methodical process of gathering testimony, reviewing medical records, and pursuing the forensic evidence that would be necessary to substantiate what witnesses were saying they had seen and heard. The most critical testimony to emerge during that investigation, and the subsequent legal proceedings, came from a nurse named Eleanor Larocco. Larocco testified under oath that the facility's director of nursing, a woman named Penny Whitlock, had made a statement to Heimabaugh that would become one of the most cited quotes in the entire case. According to Larocco, Whitlock told Heimabaugh, "I don't care if you play Angel of Death, just don't let me know about it." That statement, if accurate, suggested that supervisory staff were aware, or at minimum had been made aware in some form, of what was being alleged against Heimabaugh and had chosen not to intervene. Larocco also testified that when one of the patients died, Director Whitlock's response was to laugh and ask, "What is this? 5 or 6 now?" That testimony, delivered in a court of law under oath, painted a picture of an institutional environment in which oversight had broken down at multiple levels. A state investigatory report further alleged that Heimabaugh had given restless patients what witnesses described as drug cocktails. The report also documented that Heimabaugh had made a statement, in the presence of staff, about a 56-year-old patient with Down syndrome, saying, according to the report, "Those people aren't meant to live that long." That statement became part of the documented record of the case. The forensic component of the Illinois State Police investigation was extensive. 3 of the 6 bodies were exhumed and subjected to post-mortem toxicological analysis. Exhumation is not a routine investigative step. It requires court authorization, cooperation from families, coordination with medical examiners, and a level of evidentiary confidence that something in the original death investigation warrants revisiting. The fact that the state police pursued exhumation in 3 cases indicates the seriousness with which they treated the available witness testimony. The chief of the Cook County Medical Examiner's Office testified regarding the toxicological findings in the case of Tony Hodges, the hospice patient who became the subject of Himabaw's eventual guilty plea. The medical examiner's testimony stated that Hodges was intoxicated with a drug that he should have never received. That testimony established the forensic foundation for the criminal charge, that a prescription medication had been administered to a patient without authorization, with consequences for his health and ultimately his death. Marty Himabaugh and her nursing supervisor, Penny Whitlock, were arrested on the 4th of April 2008, nearly 2 years after the deaths in question. Both faced multiple felony charges. For Himabaugh, the charges included criminal neglect of long-term care residents, obtaining a controlled substance by fraud, and unlawful delivery of a controlled substance. Each charge carried Class 4 felony status under Illinois law. The case proceeded through the McHenry County court system over the following 3 years, a period that included pretrial motions, evidentiary hearings, and the companion proceedings against Whitlock. The prosecution was handled by Assistant State's Attorney Philip Hiscock of the McHenry County State's Attorney's Office. Himabaugh was represented by defense attorney Sam Amarante. On the 13th of October 2011, more than 5 years after the deaths in question, Marty Himabaugh pleaded guilty to a single felony count of criminal neglect of a facility resident. The guilty plea specifically admitted that she had administered a prescription drug to Tony Hodges without authorization. In exchange for the plea, the remaining felony counts were dismissed. On the 14th of December 2011, Circuit Court Judge Joseph Condon sentenced Himabaugh to 2 years probation and a $5,000 fine. She lost her nursing license. She would not return to the nursing profession. Judge Condon did not deliver the sentence without commentary. He expressed what he described as serious doubts about the handling of the case and the investigation. The judge noted that numerous nurses had testified to observing what they believed to be over-medication at Woodstock residents, yet none of those nurses had contacted law enforcement at the time. The judge's observation raised a question that the case left unresolved. In a facility where multiple staff members observed a concerning pattern, why did institutional reporting mechanisms not function as they were designed to? The companion case against Director of Nursing, Penny Whitlock, produced a different outcome entirely. Whitlock had been charged with criminal neglect and obstruction of justice, including allegations that she had ordered staff to destroy medications. On the 26th of April 2011, some of the counts against Whitlock were dismissed. On the 27th of April 2011, 1 day later, Judge Condon acquitted Whitlock on all remaining counts at a bench trial. The obstruction of justice charge, the criminal neglect charges, all of them were resolved in her favor. Whitlock left the courthouse without a conviction. That contrast, a line nurse pleading guilty to 1 felony count, a director of nursing acquitted on all charges, became one of the defining features of this case. It illustrated a persistent challenge in prosecuting institutional patient harm. The closer a defendant is to the supervisory level, the more difficult it becomes to establish direct criminal responsibility in court. The families of at least 2 of the patients were not finished with the legal process after the criminal proceedings concluded. Wrongful death civil suits were filed by the families of Virginia Cole and John Sherman. Civil proceedings operate under a different evidentiary standard than criminal trials, and they provided a separate avenue for the families to pursue accountability through the court system. The Woodstock residents case raised questions that reached well beyond the walls of one nursing home on McHenry Avenue. How long had the pattern continued before anyone acted? Who knew what and when? Why did the system that was supposed to protect these patients, the facility's internal reporting structure, the state licensing apparatus, the professional obligations of every licensed nurse who observed the conduct, not intervene sooner? Those questions, documented in court records and in the testimony of the nurses who eventually came forward, define the legacy of this case in the Illinois long-term care system. Case 2, Nicole Butler. On the 16th of May 2021, at a skilled nursing facility in the Northern District of Illinois, a registered nurse allegedly removed a patient's prescribed liquid morphine from its dispensing location and replaced it with a diluted mixture. The patient, who had a legitimate medical prescription for that morphine, was then administered the tampered substance. That single act, the removal of a medication intended for a seriously ill patient and its replacement with a diluted version formed the basis of a federal criminal indictment unsealed in December of 2023. This is Case 2. Nicole Butler was 40 years of age at the time of her federal indictment. She was a registered nurse, licensed in the state of Illinois, residing in Byron, Illinois, a small city in Ogle County located on the Rock River, roughly 100 miles west of Chicago. She had the professional training, the clinical credentials, and the facility access that allowed her to interact with controlled medications on behalf of patients in her care. The facility where the alleged tampering occurred has not been publicly named in available court filings, though it has been characterized as a skilled nursing facility operating within the Northern District of Illinois. Skilled nursing facilities are licensed, regulated healthcare environments that provide around-the-clock nursing care to patients who require more intensive medical attention than can be provided at home or in a standard residential setting. Patients in such facilities are often elderly, post-surgical, or managing serious chronic conditions. They are, by definition, dependent on nursing staff to administer their medications correctly and in the doses prescribed by their physicians. Morphine is a Schedule II controlled substance under federal law. Its use in skilled nursing facilities is carefully regulated and is typically confined to patients requiring significant pain management, often including patients in end-of-life or palliative care. The medication is tracked from pharmacy dispensation through to patient administration, with documentation requirements designed to account for every unit dispensed. When a patient is prescribed liquid morphine, the expectation built into every layer of the regulatory system is that what reaches that patient is exactly what was prescribed, not a substitute, not a diluted mixture, not a tampered product. According to the federal indictment returned against Butler, that expectation was violated. The indictment alleged that on the 16th of May, 2021, Butler removed liquid morphine prescribed to a specific patient and replaced it with morphine that had been diluted with another liquid. The indictment further alleged that Butler did this knowing the diluted product would be dispensed to the patient, and that she acted, in the language of the federal charging document, with reckless disregard and extreme indifference for the risk that the patient would be placed in danger of bodily injury. The charge filed against Butler was one federal count of tampering with a consumer product under Title 18, United States Code, Section 1365. Federal product tampering statutes were originally designed in the context of consumer product contamination, but courts have upheld their application in healthcare settings where medications are tampered with before reaching patients. The statute carries a maximum sentence of 10 years in federal prison. The investigation that led to Butler's indictment was conducted by multiple federal and state agencies working in coordination. The lead investigative agency was the United States Food and Drug Administration, Office of Criminal Investigations, the FDA's law enforcement arm, which handles criminal violations involving drugs, medical devices, and food safety. The investigation also received substantial assistance from the Illinois State Police and from the United States Department of Health and Human Services, Office of Inspector General, which investigates fraud and other violations within federally funded healthcare programs including Medicare and Medicaid. The involvement of the FDA's Office of Criminal Investigations is significant and worth examining in context. The FDA OCI does not pursue routine employment misconduct cases. Its jurisdiction over this matter reflected the federal government's position that tampering with a patient's medication in a healthcare facility implicates not just state employment law or professional licensing standards, but federal statutes governing the safety and integrity of drugs distributed in interstate commerce. Morphine prescribed to a patient is a regulated pharmaceutical product, and its integrity is a matter of federal regulatory concern. The indictment against Butler was returned by a federal grand jury and remained sealed for a period before it was unsealed and the case made public. On the 21st of December 2023, approximately 2.5 years after the alleged conduct, Butler was arraigned in the United States District Court for the Northern District of Illinois in Chicago. At that arraignment, she pleaded not guilty to the single federal count. The unsealing and announcement of the indictment was made by acting United States Attorney Morris Pasquale, who served as the head of the Northern District of Illinois at that time. The FDA's Office of Criminal Investigations was represented in the announcement by Special Agent in Charge Ron Malham. The government's prosecution of the case was handled by Assistant United States Attorney Misty N. Wright, according to the Department of Justice press release issued at the time of the arraignment. The Department of Justice statement announcing the indictment included clear and standard legal language. An indictment is not evidence of guilt. The defendant is presumed innocent and entitled to a fair trial, at which the government has the burden of proving guilt beyond a reasonable doubt." End quote. That principle is foundational to how this case, and every case in this documentary, must be understood. At the time of indictment, Nicole Butler was a charged defendant, not a convicted one. The question of case disposition, whether Butler ultimately pleaded guilty, went to trial, was convicted, or had charges dismissed, was pending at the time the available source materials were compiled. Viewers who wish to track the current status of this case are encouraged to search the Public Access to Court Electronic Records System, known as PACER, using Northern District of Illinois Case Number 23 Criminal 649. What the Butler case illustrates, regardless of its eventual resolution, is the federal architecture that exists to address medication tampering in healthcare settings. The collaboration between the FDA OCI, the Illinois State Police, and the HHS Office of Inspector General represents a multi-agency response to what is, at its core, a patient safety violation, one that occurs when a person entrusted with access to a patient's controlled medications uses that access in a manner inconsistent with the patient's medical orders. The Butler indictment also reflects a broader enforcement trend. In the decade prior to her indictment, federal prosecutors in multiple districts had charged nurses and other healthcare workers with federal product tampering violations, specifically in the context of medication diversion, cases where staff removed medications intended for patients and replaced them with diluted or substitute substances. These cases, documented in jurisdictions from New England to the Midwest, established the legal precedent under which the Butler indictment was built. The patient whose morphine was allegedly tampered with in this case has not been publicly identified. What the indictment makes clear is that this was a real patient, with a real prescription, dependent on facility staff to deliver that prescription accurately. The alleged failure to do so, if proven, represents a violation of both federal law and the professional obligations that define what it means to hold a registered nursing license in the state of Illinois. Case 3. Cher Farley. 2 patients in LaSalle County, Illinois, were hospitalized with botulism in the spring of 2024. The Illinois Department of Public Health announced it was investigating a licensed nurse who had injected both of them with a product she represented as Botox. It was not the commercially approved product. It had come from overseas, and the nurse administering it had no legal authority to obtain or inject it. This is Case 3. Cher Farley was 52 years of age at the time the charges described in this case were filed. She was a registered nurse, licensed in the state of Illinois, residing in Earlville, a small community in LaSalle County in north-central Illinois, approximately 70 miles southwest of Chicago. She had held a nursing license, a professional credential that represents years of supervised training, examination, and regulatory oversight. By the time her case became public, that license had been suspended. The context for this case is the cosmetic injection industry, which has experienced rapid expansion in communities throughout the United States, including in smaller Illinois cities and towns. Botulinum toxin, sold under the commercial brand name Botox, among others, is an FDA-regulated injectable pharmaceutical used for cosmetic and medical purposes. In the United States, only the commercially approved formulation is legally authorized for use. That product is manufactured under strict pharmaceutical standards, dispensed through licensed pharmacies, and may only be administered pursuant to a valid prescription. The administration of injectable cosmetic treatments by a nurse requires both a proper prescription order and operation within the scope of the nurse's licensed authority, typically under the direction of a licensed physician or advanced practice provider. Farley is alleged to have operated entirely outside that legal framework. According to the state and federal investigative record, she obtained injectable products from overseas, specifically products originating from or sourced through China, that were labeled as Botox or Sotox, a separate brand name for a botulinum toxin product. These products had not been approved by the Food and Drug Administration for use in the United States. They were not the commercially approved pharmaceutical. They were foreign-sourced, unapproved substances marketed to mimic a regulated product. The Illinois Department of Public Health's April 2024 announcement stated that 2 people in LaSalle County had been hospitalized after being injected by a licensed nurse working outside their authority. Botulism, the condition both patients developed, is a serious illness caused by botulinum toxin, affecting the nervous and muscular systems. Both patients required hospital-level medical care as a direct result of the injections. The administrative enforcement response was swift. Within weeks of the IDPH announcement, the Illinois Department of Financial and Professional Regulation took action against Farley's registered nursing license. The IVPR's May 2024 enforcement report documented that Farley's license was suspended for a minimum of 2 years after she illegitimately obtained Botox and injected it without proper authority into at least 2 people who were hospitalized and diagnosed with botulism. The IDPR enforcement process is separate from and concurrent with any criminal proceeding. It addresses the nurse's professional credentials and her fitness to continue practicing, regardless of how the criminal matter is resolved. The criminal dimension of this case extended to the federal level. Sheriff Farley was charged in the 2025 National Healthcare Fraud Takedown, a coordinated annual enforcement action conducted by the Department of Justice in partnership with the Department of Health and Human Services and numerous federal investigative agencies. The 2025 takedown charged 324 defendants across the United States in schemes that, taken together, involved more than $14.6 billion in intended losses to the healthcare system. Farley was among 13 defendants charged in the Northern District of Illinois as part of that action. The criminal information filed against Farley alleged violations related to the acquisition and introduction into interstate commerce of misbranded foreign-source drugs. The conduct at issue was alleged to have occurred on 5 occasions between May of 2023 and March of 2024, a period of approximately 10 months during which the foreign-sourced injectable products were allegedly obtained and used on patients. The federal charges of introducing misbranded foreign-sourced drugs into interstate commerce reflect the FDA's jurisdiction over pharmaceutical products crossing state lines and being injected into patients. When an individual obtains a drug that has not been approved by the FDA and administers it as though it were an approved product, that conduct implicates federal pharmaceutical law in addition to any state-level professional licensing violation. In this context, the patient is not the only harmed party. The integrity of the pharmaceutical regulatory system itself is at issue. The 2025 National Healthcare Fraud Takedown was announced by United States Attorney Andrew S. Boutros for the Northern District of Illinois. The cases comprising the Northern District's portion of the takedown involved a range of alleged healthcare fraud schemes, with Farley's case representing the patient safety dimension, a healthcare professional allegedly administering unapproved substances to patients without legal authorization. Several aspects of this case are instructive for understanding how patient harm in non-institutional settings comes to regulatory attention. Unlike the cases involving nursing homes or developmental centers, Farley's alleged conduct occurred in a more informal setting. She was not operating inside a licensed healthcare facility with internal oversight mechanisms, surveillance cameras, or colleague witnesses. The harm came to light through the patients themselves, who sought hospital care after experiencing adverse effects. Their hospitalization triggered the IDPH investigation, which in turn identified the source of the injections. This pathway, from patient harm to hospital presentation, to public health investigation, to licensing action, to federal criminal charge, is precisely the multi-agency regulatory architecture that exists to address patient harm in medical and quasi-medical settings outside formal hospital structures. The IDFPR license suspension represents the fastest and most direct consequence for Farley. The state removed her ability to practice as a registered nurse while the criminal matter proceeded. The federal criminal charge carries its own potential consequences, including incarceration, fines, and a federal conviction that would almost certainly result in permanent license revocation. The full disposition of the criminal information filed against Farley, whether she entered a plea, proceeded to trial, or reached a negotiated resolution, was developing at the time the source materials for this documentary were compiled. The documentary recommends that viewers consult the Northern District of Illinois federal docket for current case status. What this case established clearly and without dispute is this. Two people in LaSalle County, Illinois, were hospitalized with botulism after receiving injections from a registered nurse who obtained unapproved foreign-sourced products and administered them without legal authority. The administrative record of that harm is documented. The criminal charges are filed. The investigation was conducted by the public health and federal regulatory apparatus that exists precisely to address this category of patient harm. Case 4. Angela Hutchison. A registered nurse arrived for her shift at a skilled nursing facility in Crystal Lake, Illinois, and was found to be impaired by staff. The patients she was responsible for that day depended on her for their medication administration, their safety assessments, and their care. She was charged with criminal neglect of a facility resident, a Class 4 felony under Illinois law. This is Case 4. Angela S. Hutchison was 48 years of age at the time of the proceedings in this case. She was a registered professional nurse, having received her Illinois nursing license in 2009. She resided in McHenry, Illinois, and was employed as a registered nurse at Fair Oaks Healthcare Center, located at 471 West Terracotta Avenue in Crystal Lake, McHenry County, a licensed skilled nursing and long-term care facility providing 24-hour nursing care to residents with significant health conditions. The circumstances giving rise to the criminal complaint were documented in two separate charging instruments. The initial complaint was filed in July of 2023. A grand jury returned an indictment, adding a second count in August of 2023. Both counts alleged the same foundational violation, that Hutchison had engaged in criminal neglect of facility residents by reporting to work and remaining on duty while impaired by a substance, thereby creating what the charging language described as a substantial likelihood that the health or life of residents in her care would be endangered or that their pre-existing conditions would be worsened. The Illinois criminal statute under which Hutchison was charged, 720 Illinois Compiled Statutes 5/12-4.4a, defines criminal neglect of a facility resident as reckless conduct by an employee of a long-term care or residential facility that creates a substantial risk of death or great bodily harm to a resident. The statute is designed to address exactly this category of situation. A licensed professional whose impairment on duty transforms the ordinary risks of patient care into an elevated, legally cognizable danger to vulnerable individuals. The impairment documented in this case was substance-related. The IVPR's subsequent enforcement action against Hutchison's nursing license, which was initiated concurrently with and independently of the criminal proceedings, noted that her license was suspended for a minimum of 1 year on the basis of substance use and impairment. That administrative finding reflects the IDFPR's independent assessment of her fitness to hold a nursing license, separate from the criminal court's determination of her guilt or innocence on the specific charged counts. The criminal case was resolved by a negotiated plea agreement. In April of 2024, approximately 9 months after the initial complaint was filed, Hutchison appeared in McHenry County Circuit Court and entered a guilty plea to 1 count of criminal neglect of a facility resident. The second count was dismissed as part of the negotiated resolution. McHenry County Circuit Court Judge Mark Gerhardt presided over the sentencing. The sentence imposed reflected both the seriousness of the charge and the mitigating factors presented, including Hutchison's apparent engagement with substance use treatment. Judge Gerhardt sentenced Hutchison to 30 months of probation and 100 hours of community service. He accepted her into the McHenry County Drug Court Program, a structured supervision program designed to address substance use issues while maintaining accountability through regular court appearances, drug testing, and compliance requirements. The judge also stayed a 180-day jail sentence, meaning the custodial term was held in reserve, contingent on her compliance with probation and drug court requirements. Separately from the sentencing, the IDVFPR imposed an indefinite suspension of Hutchison's registered nursing license, with a minimum suspension period of 1 year. An indefinite suspension does not automatically restore the license at the end of the minimum period. The licensee must petition for reinstatement and demonstrate compliance with any conditions the IDFPR has imposed. The combination of criminal probation and license suspension meant that Hutchison faced an extended period of both court and regulatory oversight. The Hutchison case is significant for several reasons that extend beyond its individual facts. First, It demonstrates that Illinois maintains a specific criminal statute targeting employee conduct in long-term care facilities, a statute broad enough to reach impairment-based neglect, not just direct physical harm. The legislature's decision to criminalize conduct that recklessly creates a substantial likelihood of resident endangerment reflects a policy judgment that the vulnerability of facility residents demands a higher standard of accountability from the professionals they depend on. Second, the case illustrates the dual-track enforcement system that Illinois uses when a licensed healthcare professional commits a criminal offense. The criminal court and the IDFPR operate independently, on separate timelines, under separate evidentiary standards, and with separate consequences. A nurse who faces criminal charges may also face license suspension before the criminal case concludes. A nurse who receives a relatively lenient criminal sentence may still face extended or permanent license consequences through the IDFPR process. Third, the involvement of drug court in Hutchison's disposition reflects a recognition that substance use impairment in healthcare settings is both a patient safety issue and a public health issue. The drug court model, which has been used in McHenry County and throughout Illinois for decades, is designed to address the underlying condition driving the criminal conduct while maintaining judicial oversight and accountability. The residents of Fair Oaks Healthcare Center who were present on the shift in question, the individuals whose safety the prosecution argued was endangered by Hutchison's impaired state, are not publicly identified in the available record. Their vulnerability as residents of a skilled nursing facility and their dependence on the nurses assigned to their care is what the criminal statute is designed to protect. This case, resolved through the McHenry County courts in the spring of 2024, stands as a documented example of how Illinois' legal system responds when the professional standard of care breaks down at the point of individual employee conduct. Case 5. Isaiah Fields. In April of 2024, staff at a residential care facility near Geneva, Illinois, made a discovery that prompted an immediate investigation by the Kane County Sheriff's Office. A 43-year-old female resident had become pregnant. The resident had Rett syndrome and was, according to prosecutors, unable to communicate, unable to ambulate independently, and entirely dependent on facility staff for all aspects of her care. She could not have consented to any sexual contact. The pregnancy could only have been the result of criminal conduct by a member of the staff. This is Case 5. The facility was Markland Hyde Center, a residential care facility located near Geneva in Kane County, Illinois. Markland Hyde Center is operated by Markland, a nonprofit organization that provides residential services to approximately 96 adults with profound developmental disabilities. These are individuals who require comprehensive support for daily living activities, and who, by the nature of their conditions and legal status, are among the most protected classes of persons under Illinois law. Their vulnerability is precisely why the staffing of such facilities is subject to extensive background check requirements, training standards, and regulatory oversight. Isaiah Fields was 22 years of age at the time of the offense. He had been employed at Markland Hyde Center for approximately 1 month during the summer of 2023, a period of employment that ended, according to available reporting, before the investigation began. He was residing in Chicago at the time of his employment and subsequently in Batavia, Kane County. He was not a licensed nurse, a licensed practical nurse, or any category of licensed healthcare professional. He was a direct care staff member, a facility employee assigned to assist residents with daily activities. The investigation conducted by the Kane County Sheriff's Office represents a model of how forensic science is applied in cases where the victim cannot provide a verbal account of what occurred. The resident, because of her condition, could not communicate with investigators about what had happened to her. The forensic investigation, therefore, had to establish both the fact of the criminal conduct and the identity of the perpetrator through physical evidence. The primary forensic tool used was DNA analysis. The Kane County Sheriff's Office determined that a DNA sample from the perpetrator would be contained within evidence obtained in connection with the pregnancy. Investigators then took the step, a significant and operationally demanding one, of obtaining buccal swab DNA samples from every current and former male employee of the facility. The scope of that collection effort reflected both the seriousness of the case and the investigators' methodical approach to identifying the responsible party through science rather than assumption. When the DNA profiles obtained from the employee swabs were compared to the forensic evidence, the profile belonging to Isaiah Fields matched. That match constituted the critical physical evidence linking Fields to the crime. Based on that evidence, Kane County Sheriff's investigators obtained a sealed arrest warrant. The victim gave birth to a boy. Prosecutors in the case stated that the infant died after spending 11 weeks in a neonatal intensive care unit. Assistant State's Attorney Matthew Rogers, speaking at the sentencing, addressed the infant's brief life and the manner in which the infant's existence served as the evidence that brought the case forward. He didn't live long in this world, but simply by coming into this world, he did justice for his mother. Fields was charged with aggravated criminal sexual assault, a Class X felony, which is the most serious non-homicide classification under Illinois criminal law. Class X felonies carry mandatory minimum prison sentences and are not eligible for probation. On the 14th of January 2025, Isaiah Fields appeared in Kane County Circuit Court and entered what is called a cold plea of guilty, a guilty plea entered without any negotiated agreement with the prosecution. The case then proceeded to a sentencing hearing. On the 14th of March 2025, Kane County Circuit Court Judge John Barsanti sentenced Fields to 25 years in the Illinois Department of Corrections. The sentence came with additional conditions. Fields was required to register as a sex offender for the remainder of his life, and he is required to serve at least 85% of his 25-year sentence before becoming eligible for release consideration. At 85% service of a 25-year term, Fields would not be eligible for release until he had served more than 21 years. The case was prosecuted by the Kane County State's Attorney's Office under State's Attorney Jamie Mosser. The courtroom prosecution team included Assistant State's Attorneys Matthew Rogers and Hillary Sadler. The investigative work was conducted by Kane County Sheriff's investigator Brooke Mineth. Victim advocate Linda Hageman was present in support of the victim and her family throughout the proceedings. In the aftermath of the case, significant attention was directed at the facility's hiring and oversight practices. The fact that Fields had been employed for only approximately 1 month before his departure, and that the assault had allegedly occurred during that brief employment period, raised questions about the adequacy of background checks, supervision of new employees, and the general security arrangements at facilities caring for nonverbal residents with profound disabilities. The Markland Hyde Center case is significant not only for the severity of the crime and the sentence, but for what it demonstrates about the evidentiary power of DNA forensics in cases where traditional witness testimony is unavailable. The investigation, conducted by the Kane County Sheriff's Office through systematic DNA collection and comparison, produced unambiguous physical evidence that the legal system could act upon. It also demonstrates the importance of the legislative framework governing Class X felony sentencing in Illinois. The mandatory minimum sentencing structure for crimes of this nature, combined with the 85% service requirement, reflects a legislative determination that certain categories of harm to the most vulnerable members of society warrant the most serious available criminal consequences short of homicide. Case 6. Penny Whitlock. There are cases in which the evidence produced at trial is not sufficient to sustain a criminal conviction. Cases in which individuals are charged, prosecuted, and ultimately acquitted by a court of law. This is one of those cases. And it belongs in this documentary precisely because understanding the limits of criminal accountability is as important as documenting the instances where accountability is achieved. This is Case 6. Penny Whitlock was the director of nursing at Woodstock Residence Nursing Center in Woodstock, McHenry County, Illinois, the same facility featured in Case 1 of this documentary. She held the most senior nursing position at that facility, a role with responsibility not just for her own clinical conduct, but for the oversight, supervision, and professional accountability of every nurse under her direction. The charges against Whitlock arose from the same sequence of events that formed the basis of the criminal case against licensed practical nurse Marty Heimabaugh. Between the 2nd of April and the 18th of September, 2006, 6 patients at Woodstock Residence died under circumstances that investigators ultimately concluded warranted criminal scrutiny. The Illinois State Police investigation, which ran for 15 months, examined the deaths of all 6 patients and gathered the testimony that would form the foundation of the prosecutions of both Heimabaugh and Whitlock. Whitlock was arrested on the 4th of April, 2008, alongside Himabaugh. The charges against her included criminal neglect of long-term care facility residents and obstruction of justice. The obstruction of justice allegation was specific. Prosecutors alleged that Whitlock had ordered members of the nursing staff to destroy medications, a charge that, if proven, would have established that she had taken active steps to conceal evidence of the conduct occurring under her supervision. The testimony that most directly implicated Whitlock came from nurse Eleanor LaRocco, whose account under oath included the statement that Whitlock told Himabaugh she did not care if Himabaugh played Angel of Death as long as Whitlock was not told about it. LaRocco also testified that Whitlock responded to news of a patient death with a comment suggesting awareness that multiple deaths had occurred. These statements, if the court accepted them as credible and accurate, would have established that Whitlock had knowledge of what was occurring and chose not to stop it. The prosecution's theory was, in essence, a supervisory accountability argument, that a director of nursing, who is made aware that a nurse under her supervision is administering unprescribed medications to patients, and who responds not by intervening, reporting, or investigating, but by indicating she prefers not to be informed, bears criminal responsibility for the harm that results from that conduct. That theory did not succeed in court. The prosecution of Whitlock proceeded through the McHenry County Circuit Court system over several years. On the 26th of April 2011, several counts against her were dismissed before the case reached its conclusion. On the 27th of April 2011, one day later, Circuit Court Judge Joseph Condon presided over a bench trial on the remaining counts and acquitted Whitlock on all of them. The obstruction of justice charges were resolved in her favor. The criminal neglect charges were resolved in her favor. She left the proceedings without a criminal conviction. A bench trial is a trial without a jury, in which the judge serves as both the finder of fact and the applier of law. In a bench trial, the judge evaluates the credibility of witnesses, weighs the evidence, and determines whether the prosecution has met its burden of proof beyond a reasonable doubt. Judge Condon's acquittal of Whitlock reflected his determination that the evidence presented did not meet that standard on any of the surviving charges. The acquittal does not mean the court found that the alleged conduct did not occur. An acquittal in a criminal proceeding means only that the prosecution did not meet its burden of proof in that proceeding, under the applicable legal standards and before that particular finder of fact. The statements attributed to Whitlock by Nurse LaRocco remain part of the documented testimony in this case, statements made under oath, in open court, as part of a criminal proceeding. The contrast between the outcomes in Case 1 and Case 6 is striking and worth examining in detail. Marty Himabaugh, the line nurse, the individual who allegedly administered the medications directly, pleaded guilty to a single felony count and received a sentence of 2 years probation and a $5,000 fine. Penny Whitlock, the director of nursing, the individual alleged to have created the supervisory environment in which the conduct occurred and to have actively obstructed the investigation, was acquitted of all charges. That outcome reflects a broader pattern in the prosecution of institutional patient harm. It is generally easier to prosecute the individual who directly administered a medication than the supervisor who allegedly permitted, tolerated, or concealed that conduct. Direct criminal liability is more straightforwardly established through physical evidence and individual acts. Supervisory liability requires proof of knowledge, intent, and connection to specific harm that can be substantially more difficult to establish beyond a reasonable doubt. The families who filed wrongful death civil suits in connection with the Woodstock residents' deaths, the families of Virginia Cole and John Sherman, specifically, had a separate avenue available to them through the civil courts. Civil proceedings apply a preponderance of the evidence standard, which is meaningfully different from the beyond a reasonable doubt standard in criminal proceedings. The outcomes of those civil cases are not fully documented in the sources available for this documentary, but their filing reflects the family's continued effort to obtain some form of accountability through the legal system. The Whitlock case stands as a documented example of the institutional accountability gap, the documented difficulty of holding supervisory and administrative personnel criminally responsible for patient harm that occurs under their professional oversight. Case 7. The Choate Mental Health and Developmental Center. For more than a decade, a state-run facility in southern Illinois was the subject of more than 1,500 formal reports of employee abuse and neglect. The Illinois State Police opened 40 investigations. 26 employees were charged with felonies. One employee was convicted of a felony for hiding evidence, not for the underlying abuse. No one served a day in prison for the harm done to the residents of Choate Mental Health and Developmental Center. This is Case 7. Choate Mental Health and Developmental Center is located in Anna, Illinois, in Union County, a small city in the southernmost part of the state. The facility is operated by the Illinois Department of Human Services, a state agency, and serves approximately 270 residents, adults with intellectual and developmental disabilities, and adults with mental health conditions who require residential care and supervision. The residents of Choate are, in many cases, individuals who cannot fully advocate for themselves, who depend on facility employees for their basic daily needs, and who are among the most legally protected and socially vulnerable populations in the state. The scale of what the documentation reveals is significant. According to reporting by ProPublica in partnership with Capital News Illinois, published in September of 2022, the ID's Office of Inspector General received and investigated more than 1,500 reports of alleged employee abuse or neglect at Choate over a 10-year period ending in 2021. The breakdown of those reports by category was as follows: approximately 800 allegations of physical abuse, approximately 100 allegations of sexual abuse, and approximately 600 allegations of mental abuse, financial exploitation, or neglect. 1,500 individual reports. Over 10 years, at one facility, the Illinois State Police, which has jurisdiction over criminal investigations at state-operated facilities, opened at least 40 investigations stemming from those reports over the same period. Of those 40 investigations, 12 produced felony charges against a total of 26 employees. And of those 26 employees charged with felonies, precisely one was convicted of a felony. That conviction was not for physical abuse of a resident. It was for obstruction of justice, for discarding evidence of abuse. The named convicted defendant was Mark Allen, a mental health technician at Choate, not a licensed nurse. Allen had initially been charged with felony aggravated battery in connection with the beating of a resident named Blaine Reichard in December of 2014. That charge was not what resulted in a conviction. Instead, Allen pleaded guilty to felony obstruction of justice, specifically for discarding a bloody towel that constituted physical evidence of the assault. He received a sentence of 2 years probation. 3 co-defendants in the Reichard matter, Kurt Ellis, Justin Butler, and Eric Biddle, pleaded guilty to misdemeanor charges of failing to report abuse. None received jail time. None were convicted of a felony. The ProPublica and Capital News Illinois reporting used Allen's case to illustrate the broader pattern, noting that he holds the distinction of being the only employee at Choate convicted of a felony related to patient maltreatment in at least a decade. That is the documented outcome of 12 felony prosecutions covering conduct reported in more than 1,500 formal complaints over 10 years at a single state-run facility. The investigative pathway that existed at Choate during the decade in question ran from the facility's own internal reporting, to the ID's Office of Inspector General, to the Illinois State Police, to the Office of the State's Attorney for Union County. Each of those institutions had a role to play in investigating and prosecuting the alleged abuse. The ProPublica and Capital News Illinois reporting documented multiple points at which that pathway failed to produce accountability, investigations that were closed without charges, charges that did not result in convictions, and a culture within the facility that the reporting described as tolerant of misconduct. Surveillance cameras in common areas of the facility were not mandated until 2023, a reform implemented in the aftermath of the investigative reporting. Before that reform, much of the alleged abuse had no video documentation, creating evidentiary challenges for investigators and prosecutors trying to establish what occurred in an environment where the residents who were present could not reliably testify, and the staff members present had reasons not to cooperate with investigators. The installation of cameras represented a shift in the investigative toolkit available to the state police and prosecutors going forward. It also reflected an implicit acknowledgement that the prior oversight mechanisms had not been adequate to detect, document, or deter the conduct described in the 1,500 reports filed over the preceding decade. 2 more recent charges illustrate the ongoing nature of the accountability problem at Choate, even after the 2022 reporting. John Curtis Spaulding was charged with felony aggravated battery after being captured on camera. Joseph A. Clark, 24 years of age, was charged with felony aggravated battery in February of 2024. Both of those cases were pending at the time the source materials for this documentary were compiled. The Choate case also triggered federal attention. The United States Department of Justice opened a civil rights investigation encompassing Choate, Mabley Center, and Shapiro Developmental Center, an investigation conducted under the Civil Rights of Institutionalized Persons Act, which authorizes the federal government to investigate conditions in state-run institutions and take legal action where constitutional violations are found. The Choate case is not, in technical terms, a case about nurses committing crimes against patients. The employees charged in connection with the documented abuse at Choate were primarily mental health technicians, direct care workers, and aides, not licensed nurses. That distinction matters and is maintained in this documentary. What the Choate case represents is a systemic failure of the protective environment that licensed professionals, including nurses, supervisors, and administrators, are part of maintaining in any residential care facility. When the system works, licensed professionals and unlicensed direct care staff operate together under a supervisory structure that detects, reports, and addresses misconduct. When the system fails at an institutional level, when abuse is normalized, when reporting mechanisms are not used, when investigators face evidentiary barriers, and when prosecutions do not produce convictions, the residents who depend on the entire system suffer the consequences. The 1,500 reports filed at Choate over a decade and the single felony conviction that resulted represent the documented outcome of that systemic failure. Case 8, Shapiro Developmental Center. In the fall of 2023, a former nursing assistant at a state-run facility in Kankakee, Illinois, contacted investigators and described what she said she had witnessed during her employment there. The account she provided and the subsequent investigation it triggered brought renewed attention to patient safety at another Illinois Department of Human Services facility, one that had already been the subject of prior enforcement action. This is Case 8, Samuel H. Shapiro Developmental Center is located at 100 East Jeffrey Street in Kankakee, Illinois, a mid-sized city in Kankakee County, approximately 60 miles south of Chicago. Like Choate, Shapiro is a state-operated residential facility administered by the Illinois Department of Human Services and serves adults with intellectual and developmental disabilities. These are individuals who require comprehensive residential care and who, by the nature of their conditions, are particularly vulnerable to abuse and neglect by the staff employed to serve them. The whistleblower account that became the basis of the 2023 investigation was detailed and specific. The former nursing assistant described staff members engaging in a range of actions constituting alleged abuse of residents, including placing pillowcases over residents' heads, choking residents, and denying them access to food and bathroom facilities. These were serious allegations, describing conduct that, if proven, would constitute both criminal battery and a violation of residents' federally protected civil rights. On the 30th of September, 2023, the Illinois State Police responded to an abuse allegation at Shapiro and opened a formal investigation. The ID's Office of Inspector General also conducted its own parallel inquiry. As of the time the source materials for this documentary were compiled, the combined state investigations into the specific allegations described by the whistleblower had not produced confirmed criminal convictions in connection with that account. The Shapiro case, as documented, also includes an earlier, separate incident that resulted in a criminal resolution. A facility worker accused of physically abusing a resident was prosecuted and convicted of misdemeanor battery. The sentence imposed was 12 months of court supervision. The worker was terminated from employment at the facility. Investigators in that earlier case noted that while the battery conviction was obtained, they could not determine the cause of more extensive injuries documented on the resident. Injuries that went beyond what the battery conviction addressed. That gap in the investigative and prosecutorial outcome parallels the pattern documented at Choate in Case 7 of this documentary. The federal dimension of the Shapiro situation mirrors the Choate case. The United States Department of Justice, through its Civil Rights Division, opened a civil rights investigation into conditions at both Choate and Shapiro under the Civil Rights of Institutionalized Persons Act. That investigation examined whether conditions at the state-run facilities amounted to constitutional violations that warranted federal intervention. The DOJ investigation represents the federal government's assessment that the state-level oversight of these facilities had not adequately protected residents' rights. Illinois had previously been the subject of a DOJ civil rights agreement in connection with its treatment of individuals with disabilities, an agreement requiring the state to expand community-based services as an alternative to institutional placement. The Choate and Shapiro investigations represent a separate thread of federal engagement, focused specifically on the safety of individuals who remain in institutional settings. The whistleblower in the 2023 Shapiro investigation took a significant professional and personal risk in coming forward. Whistleblower protections for state employees in Illinois are codified in statute, but the practical reality of reporting misconduct in a workplace can involve consequences that statutory protections do not fully mitigate. The willingness of individuals with first-hand knowledge to contact investigators and the investigative capacity to act meaningfully on those reports is a critical component of any functioning accountability system in residential care. The Shapiro case also illustrates the relationship between individual criminal accountability and systemic reform. While the specific allegations described by the 2023 whistleblower had not yet produced criminal convictions at the time of this documentary's research, the investigation generated institutional attention and regulatory review. The installation of surveillance cameras in common areas at state-run developmental centers, implemented as a reform following the Choate investigation, extended to Shapiro as well, improving the evidentiary landscape for future investigations. The resident population at Shapiro, like that at Choate, includes individuals who cannot provide verbal accounts of what has been done to them. They depend on staff to act professionally, and on the oversight system to detect when staff do not. The documented record at Shapiro, including prior misconduct, a partial criminal resolution, ongoing investigations, and a federal civil rights inquiry, reflects both the vulnerability of that population and the persistent challenges of protecting them. This case is presented in this documentary not as a case of confirmed nurse criminality, but as a documented example of the institutional care environment in which patient harm occurs in Illinois, and the investigative and legal responses that are triggered when that harm comes to light. Case 9. DeVette Cobbs. A 79-year-old man, a resident of a licensed long-term care facility in Burr Ridge, Illinois, was the alleged victim of an attack by a staff member assigned to his care. The incident was witnessed by other employees. The staff member was charged with aggravated battery. She was fired. This is Case 9. DeVette Cobbs was approximately 54 or 55 years of age at the time of the alleged incident. She was employed as a certified nursing assistant, commonly known as a CNA, a position that requires completion of a state-approved training program and certification examination, but does not constitute licensed professional nursing. CNAs perform fundamental care tasks, including assisting with daily living activities, helping with mobility, monitoring residents' basic conditions, and providing companionship and support. They work under the supervision of registered nurses and licensed practical nurses and are an essential component of the direct care workforce in long-term care settings. Cobbs was employed at Brookdale Burr Ridge, located at 6801 High Grove Boulevard in Burr Ridge, DuPage County, Illinois. Brookdale is a national senior living company operating assisted living, memory care, and independent living communities across the United States. The Burr Ridge location has subsequently operated under the name Dimensions Living Burr Ridge. It is a licensed residential care community regulated by the Illinois Department of Public Health and subject to the same broad framework of patient protection laws that govern nursing homes and other long-term care settings. The alleged incident occurred on the 24th of July, 2020. According to the charging documents filed by the DuPage County State's Attorney's Office, Cobbs physically struck a 79-year-old male resident during the course of a care interaction. The incident was observed by at least one other employee of the facility, whose account formed part of the evidentiary basis for the criminal charges. The resident involved was not publicly identified in available reports. The charges filed against Cobbs were 2 counts of aggravated battery, Illinois law establishes aggravated battery as a distinct and more serious offense when the victim is 60 years of age or older, a provision designed to provide enhanced protection to elderly individuals who are disproportionately represented in residential care settings and who may be particularly vulnerable to harm from the individuals assigned to provide their care. The two-count charging reflects the two discrete contact incidents alleged in the charging instrument. Cobbs was terminated from her employment at Brookdale Burr Ridge following the incident. The DuPage County State's Attorney's Office filed the charges and prosecuted the matter. The aggravated battery statute under which she was charged falls within the Class 3 felony range when the victim is a senior citizen, carrying potential consequences that include a period of imprisonment. A critical clarification is necessary regarding the legal status of this case. The available source materials for this documentary do not confirm the final disposition of the charges against Cobbs. A charge is not a conviction. A defendant is presumed innocent, unless and until a jury or judge finds otherwise beyond a reasonable doubt, or unless the defendant enters a guilty plea. The documentation available establishes that Cobbs was charged, that she was employed as a CNA at the time, that she was terminated following the incident, and that the case was being prosecuted by the DuPage County State's Attorney's Office. The final outcome, conviction, acquittal, dismissal, or plea, is not confirmed in the materials available. The Cobbs case is included in this documentary because it illustrates several important features of how patient protection laws function in Illinois long-term care settings. First, it demonstrates that aggravated battery laws specifically enhanced for elderly victims apply to all care facility staff, not just licensed nurses. A CNA who harms a resident faces the same enhanced criminal exposure as any other care professional. Second, the witness-employee dimension of the case illustrates that the most effective deterrent to staff-on-resident misconduct in long-term care is often not supervisory oversight, but peer accountability, the willingness of coworkers who observe misconduct to report it. Third, this case illustrates the IDPH's role in monitoring incidents at licensed facilities. When an incident of alleged patient abuse occurs at a DuPage County long-term care facility, the IDPH receives notification and may conduct its own inspection and citation process independently of the criminal proceeding. The facility's obligation to report incidents of alleged abuse to the IDPH is a regulatory requirement, and the IDPH's findings, including any citations issued to the facility for failure to protect residents, are part of the documented record. The broader context for the Cobbs case is the documented prevalence of resident-on-staff and staff-on-resident incidents in long-term care settings across Illinois and nationally. Research on long-term care facility safety consistently identifies staff training, adequate staffing ratios, robust reporting mechanisms, and supervisory accountability as the primary institutional factors affecting whether resident abuse occurs and whether it is detected and addressed when it does. The documentation of individual criminal cases, like the Cobbs case, when viewed alongside systemic cases like Choate and Shapiro, provides a picture of how patient harm in Illinois long-term care settings spans the full spectrum, from individual acts of poor judgment to patterns of institutional failure. The standard established by Illinois law, that a senior citizen in a care facility is entitled to protection from physical harm by the individuals employed to care for them, and that violation of that protection may result in felony charges, is what the Cobbs prosecution represents. Case 10. The Regulatory System, Illinois Drug Diversion and License Discipline. This final case is different from those that preceded it. There is no single defendant. There is no single facility. There is no single act of harm. Instead, this case documents the broader regulatory architecture that Illinois has built to detect, address, and prevent harm caused by licensed nurses, and what that architecture reveals about the frequency with which the system is called into use. This is Case 10. Illinois regulates nursing licenses through the Department of Financial and Professional Regulation, known as the IDFPR. Every registered nurse and licensed practical nurse practicing in Illinois holds a license issued by that agency. The IDFPR has the authority to suspend, revoke, place conditions on, or refuse to renew a nursing license based on findings of professional misconduct, including criminal conduct, substance abuse, diversion of controlled substances, and violations of professional standards. Every month, the IIDFPR publishes an enforcement report that names every licensed professional whose license has been disciplined in the preceding 30-day period. These reports are public records, available on the IDFPR's official website. They list the licensee's name, the city of residence, the license type, and the nature of the disciplinary action. For nursing licenses, the actions most commonly documented include suspension for criminal conviction, suspension for substance use and impairment, suspension or revocation for controlled substance diversion, and placement on probation with conditions. A review of recent IFPR nursing enforcement reports reveals several categories of conduct that are directly relevant to patient safety. The first and most serious category is controlled substance diversion. This is the documented practice of a licensed nurse removing controlled substances from a facility's medication supply, either from a patient's prescribed medications or from facility stock, for personal use or other unauthorized purposes. When a nurse diverts a controlled substance that was prescribed to a patient and replaces it with a saline substitute or a diluted mixture, the patient receives inadequate pain management or palliative care. When a nurse diverts from facility stock, the integrity of the medication supply is compromised. The IVPR enforcement reports document this conduct with some frequency. One recent report identified a registered nurse placed in refuse to renew status, the most severe administrative action short of revocation, for diversion of fentanyl, Dilaudid, and morphine while employed as a registered nurse. The three substances named in that action are all Schedule II controlled substances, all potent opioid analgesics, and all among the most tightly regulated drugs in the clinical environment. Their diversion from a facility's medication supply is a serious patient safety issue in addition to a criminal drug offense. A separate enforcement record identified Karen Scholebohm, a registered nurse from Lake in the Hills, Illinois, who received a reprimand for failing to report her terminations from 2 hospital positions. Terminations that occurred because of suspicion of controlled substance diversion, and for failing to properly document the withdrawal, administration, and witnessed waste of controlled substances in her care. The failure to properly document waste is one of the primary methods through which diversion is detected. When a nurse removes a controlled substance under the pretense of waste but does not document the waste correctly or obtain a required witness signature, the irregularity creates a record that regulatory and investigative bodies can identify and act upon. Another enforcement record identified Michelle James, also from Lake in the Hills, Illinois, who was placed on indefinite probation for forging prescriptions and diverting controlled medications. Prescription forgery in the context of a licensed nurse represents a compounding of violations. It involves unauthorized use of prescriptive authority that the nurse does not hold, creation of fraudulent medical records, and the diversion of controlled substances obtained under false pretenses. The IEVPR enforcement system does not resolve all cases with the same consequence. The agency has a range of dispositions available, graduated in severity. A reprimand is a formal finding of misconduct that becomes part of the licensee's permanent record, but does not restrict practice. Probation may include conditions such as random drug testing, supervised practice, continuing education requirements, and prohibition from working in certain settings. An indefinite suspension removes the nurse from practice for a minimum specified period and requires petition for reinstatement. A refusal to renew effectively terminates the license. Revocation is the permanent removal of the license. The IDFPR system operates in parallel with, but independently of, criminal proceedings. A nurse who is arrested and charged criminally may face license action before the criminal case is resolved. A nurse who avoids criminal conviction may still face license discipline based on the IDPR's independent evidentiary findings. A nurse who receives a criminal sentence that does not include incarceration may still lose their license permanently. The IDPH, which regulates facilities rather than individual licensees, operates a parallel enforcement track. When a facility experiences a patient death or injury attributable to medication mismanagement, neglect, or staff misconduct, the ITH conducts a survey, an inspection designed to determine whether the facility violated any of its regulatory obligations. The ITH can cite facilities for deficiencies, impose civil monetary penalties, require correction plans, and in extreme cases, seek to revoke a facility's operating license. A documented example from the IDPOF's enforcement record is the Goldwater Care of Gibson City case, in which the agency found that medication mismanagement at the facility, specifically a month of incorrect blood thinner dosing, was directly linked to a resident's death. That finding resulted in a regulatory citation against the facility, separate from any individual criminal accountability. The interaction between the IDFPR individual licensee system and the IDFTH facility oversight system is where the full picture of patient protection comes into focus. Neither system alone is sufficient. An IV-PER action against a diverting nurse's license addresses that individual, but does not address the facility-level conditions that enabled the diversion to occur without detection. An IV-PER Act citation against a facility for medication mismanagement addresses the institutional failure, but does not directly discipline the individual nurse whose conduct caused the harm. The federal layer of this system adds a third dimension. The U.S. Department of Health and Human Services, Office of Inspector General, maintains a list of individuals and entities excluded from participation in Medicare and Medicaid programs. A nurse who diverts controlled substances from a Medicare or Medicaid participating facility may be excluded from those programs, a consequence that effectively prohibits them from being employed at any facility that receives federal healthcare funding. That exclusion is tracked through the HHS OIG's list of excluded individuals and entities, a publicly searchable database. The FDA's Office of Criminal Investigations, as documented in the Nickel-Butler case in Case 2 of this documentary, provides a federal criminal enforcement mechanism specifically for cases in which tampered medications implicate interstate commerce and federal pharmaceutical law. The involvement of the FDA OCI in Butler's case represented the activation of that federal enforcement layer in an Illinois case. The picture that emerges from the full regulatory architecture, IDFPR, IDPH, FDA OCI, HHS OIG, state police, and county prosecutors, is one of layered, overlapping systems, each designed to address a different dimension of patient harm in healthcare settings. No single system is comprehensive. Each has documented gaps. The IDFPR acts on what is reported, but cannot monitor every shift at every facility. The IDF conducts surveys, but cannot be present continuously. State police investigations require sufficient evidence for charges, and county prosecutors require evidence sufficient for conviction. The cases documented in the first 9 segments of this documentary illustrate each of those gaps in action. Marty Heimebaugh's conduct at Woodstock residence continued for 6 months before an investigation was opened. The Choate abuse continued for a decade, during which more than 1,500 reports were filed and 1 felony conviction resulted. Angela Hutchison's impairment was detected eventually, but only after she had reported for at least 1 shift in that condition. Cher Farley injected patients with unapproved foreign substances 5 times before the IDPH investigation, and federal charges followed. Each gap represents patients who were placed in harm's way in facilities and settings designed to protect them. Each case in this documentary is a point of documented failure in a system that, at every level, is supposed to prevent that outcome. The regulatory reports, the court records, the federal indictments, and the investigative journalism that form the factual foundation of this documentary series all exist because the public has a right to know when the systems designed to protect vulnerable people fail, how those failures occur, and what the legal consequences are for those responsible. That is what Hidden Case Diaries documents: the evidence, the investigation, the law, the outcome. Every case, every time.